Tui a te heke, tui a te kāhotu. Ia riki tauira nā kui piki a kei te pai nui, te pai roa i te pai o rua ki pōri i te pai o rehua i te. Ko ia tēnei ko te tākina mai rao te kawa o te pō. Tui a irunga, tui a iraro karongo te pō, karongo te au i te kōrero i te wānanga puā, takataka puā whiowhio. Puā o whia te maramahuru ku te maramahuragi katako o toki te hau no tū. No tū te wini, no tū te wana, no tū whakaputaina ki te hei au ki Te Ao Mārama. Tūturu ōwhiti whakamaua kia tīna. Haumi e, hui e i, tāi ki e. E titiro ana ki te mana o te rangi, ki te nui o te rangi, ki te tapu o te rangi. E whakatapua mai nei te korowai o tōna manaki o tōna atawhai, ki runga ki tō tātou kīngi kia tūheitia pōtatau te wherowhero tuawhitu. Ta tū mai rā ki te whare kāhui ari ki kei rato i a tātou. O tirā e tangi mapukau ana ki ngō tātou mate, ki ngā whānau pani e pōkai kaha nei tēnei wā, haere te mate, whakatika, whakangaro. E rauranga tira mā koutou kua whakawhaiti mai nei rato i tēnei ahi tēnei pō, tēnei te mihi. Kia koe kei te rangatira e hemi. Haere maira e te kai whakawā, haere maira e te māpuna kōrero o tēnei ahi o tēnei pō. He uaua ka mihi anō au ki au anō, no reira, ka mihi anau ki a koe, e mihi tahi anau ki tō wahini. He no rā, e mihi ana ki a koutou ki a tātou katoa, ngā mana o te whare wānanga o Waikato, ngā mana o te wāhanga o te ture, koutou kua puta mai rā i roto i te kaupapa o tēnei pō, tēnā koutou, kāti, kia ora mai tātou katoa. A welcome to Chief Judge Heemi Taumaunu and his family who are here, to the Pro-Vice Chancellor, to the Secretary for Justice, to all of the judges, to all of the students, to all of the whānau that have come out this evening. Tēnei te mihi atu, tēnā koutou. Whānau, I'm going to keep this relatively short. And so we've had our karakia and our mihi whakatau, so that's the formal stuff. Whew, all over. And so I'm going to pass the time now to the Pro-Vice Chancellor to come up and make an address for us this evening before introducing our keynote speaker. E te iwi, tēnā koutou, kia ora mai tātou katoa.
Tēnā koutou katoa. Welcome and good evening. My name is Alison Kirkman and I'm the Pro-Vice Chancellor. It is my great pleasure to be representing the University and Te Paringa Faculty of Law this evening. I'm delighted you're able to join us for this evening's Morris Ward McKinnon Law Lecture, and I thank the Chief District Court Judge for being this year's keynote speaker. I also want to acknowledge and welcome his wife, Ingrid, and members of his whānau, members of the judiciary, members of Norris, Ward, McKinnon, and other law firms, and the Secretary of Justice. I also want to welcome colleagues and students from Te Paringa Faculty of Law, the wider university, and other distinguished guests I may not have mentioned. Te Paringa Faculty of Law is proud of the relationship we have with Norris, Ward, McKinnon, and the firm's commitment from 2017 to sponsoring both this annual lecture series and the Norris, Ward, McKinnon PhD Scholarship Program for Legal Research. This commitment ensures that the faculty remains at the forefront of cutting-edge legal research and its dissemination within the professional community and civil society. And I'm sure that this lecture tonight is going to contribute to that cutting-edge legal knowledge. Now it gives me great pleasure to introduce Sam Hood. Sam is Managing Partner of Norris, Ward, McKinnon, and I'm inviting him to say a few words and then introduce tonight's speaker. Sam.
Ko ranginui ki runga, ko ko papa tūnuku ki raro ko ngā tangata ki Wainganui tihei Māori ora. Mi ana ki te atua, mi ana ki te kingi Māori a Tuheitia, e mi ana ki ngā mate haere atu rā, e mi ana ki a koe Chief Judge Heemi Taumaunu e te rangatira, e mi ana ki a koutou katoa, ki a koutou katoa kua hui mai nei, tēnā koutou, tēnā koutou, tēnā koutou katoa. One of the purposes of the mihi I just gave was to acknowledge those who have departed from this earth. And I know that sounds probably quite spiritual in nature, but I do want to take a moment just to acknowledge the late Warren Scotter. Warren is a legend of the Waikato legal community. He was a long-standing litigation partner in the great firm Harkness Henry. He was a staunch advocate of the Harkness Henry lecture, which is what this lecture originally was. And even when it became the Norris McKinnon lecture, Warren continued his involvement in that. At Norris McKinnon, every time this lecture rolls around, we have a chance to reflect on Warren and his contribution to the lecture and to the law. And I'd just like to acknowledge Judge Simon Menzies in particular, who would have been a long-standing partner of Warren's, and he is sorely missed. Introducing the keynote speaker in a few minutes it's hard to do the job justice, but every life has a story, and every story is an adventure. And for the Chief Judge, his adventure began in Gisborne, deep in the heart of Ngāti Porou territory, which is one of the iwi to which the Chief Judge whakapapas, the other being Ngāi Tahu. When I think of Ngāti Porou, I think of leaders and warriors. I think of Mount Hikurangi, the sacred maunga, which I believe is one of the Chief Judge's maunga. I think of Sir Apirana Ngāta, and I think in particular of the 28th Māori Battalion, and I think it was the Charlie Company that had the close affiliation with Ngāti Porou. Second Lieutenant Moana Nui Aki Wangarimu was the only member of the battalion who was awarded the VC. It was a posthumous award for gallantry in North Africa. And so when you think of tōtara like that, it's no small surprise that the Chief Judge would go on to forge his own legend. The Chief Judge spent his early years in Tauranga Bay before he went down south to Ngāi Tahu territory in Christchurch. He went to primary school and high school in Christchurch. And at the age of 16, he left high school to pursue a career in the New Zealand Army. I understand that he spent 5 years in the Army, 4 of those years in the Royal New Zealand Signal Corps as a non-commissioned officer. Now, anyone who's had any affiliation with the Army will know that it's the NCOs who run the place. And I'm sure that in addition to traditional Army discipline, the Chief Judge would have learnt the importance of clear communication. At the age of 21, I think, 1993, the Chief Judge graduated from Victoria University. I understand that he was the first member of his hapu, Ngāti Kanohi, to graduate as a lawyer. He practiced for about a year in Wellington and then returned to his roots in Gisborne in 1994 and had a 10-year career practicing as a criminal barrister in jury trials, as an advocate in the youth courts, and also as lawyer for child. In 2004, Chief Judge Taumaunu became a District Court Judge. He was the first judge to take the oath of office and allegiance in English and Te Reo, and he began his service in Whangarei, followed by Waitakere. In 2014, he transferred to Auckland and sat on the bench in Auckland, and in 2019, he became the Chief District Court Judge. If that record wasn't distinguished enough, the Chief Judge continued his service to the military. In 2012, he was appointed a Judge of the Court Martial of New Zealand, and in 2018, he became a Deputy Chief Judge of that court. He's joined today by his wife Ingrid, who I understand is Ngāti Maniapoto, and also served in the Army. I won't give a biography because she's going to be embarrassed if I do. But also joined by whānau, and I think some may be in transit as well. Ladies and gentlemen, please join me in giving a warm welcome to our guest speaker, Chief Judge Heemi Taumaunu.
Tēnā koutou katoa. Tēnā koe Sam. Tēnā hoki koe rāhui. Me te reo whakatau kua tuko mai nei e koe i tēnei rā. Kia mātou ngā hau e whā kua whakawhaiti nei i runga i te karanga o te kaupapa o tēnei pō. Nei rā ngā mihi mai o hā e tuku atu kia kingi tūheitia. I noho mai rā i rungi tāhu rewa tapu a ona mātua tipuna. Me tana hoa rangatira te atawhai, me ara o tamariki mokopuna. Tai atu rā ki te kāhui ariki whānui tonu, kaue koutou mā tēnā koutou. E aku nui, e aku rahi, e aku whakatamarahi ki te rangi, tēnā hoki koutou katoa. Koutou kua hara mai, i tēnei pō, tēnei te mihi nui ki a koutou, tēnā koutou, tēnā koutou. Kia ora tātou katoa. Can I just endorse all of the greetings that have been already extended to all of the distinguished guests who are here. You know who you are, and rather than repeat them, I just want to welcome everyone who is here and really thank you for coming. Towards the end of the 19th century, in the later years of his life, after he had experienced arrest without charge, imprisonment, armed conflict with the Crown, an official pardon, and the formation of the Ringatu religion, Te Kōti Arikirangi uttered these famous expressions. Ko te waka hei hoi hoinga mā koutou hei muri i ao, ko te ture. Mā te ture anō, te ture e aki. The canoe for you to paddle after me is the law. Only the law can be set against the law. He also said, ka kuhuau ki te ture, hei matua mo te pani. I seek refuge in the law as a parent for the oppressed. These powerful words continue to resonate and provide a relevant historical context for the modern day vision for the District Court. That vision is simply expressed. The District Court should be a place where all people can come to seek justice, no matter what their means or ability, regardless of their culture or ethnicity, and regardless of who they are or where they're from. The title of this address which has changed, is Mai te pō ki Te Ao Mārama, the transition from night to the enlightened world, calls for transformative change and the District Court response. So that title touches on three related topics. The first concerns a Maori worldview about this concept of Te Ao Mārama that has helped to shape the modern day vision for the District Court. The second topic touches on the multiple calls for transformative change that have been directed towards our court. The third topic relates to the District Court response in terms of what we have done so far and what we propose to do in the future. In this regard, I intend to speak about the District Court generally, and I also intend to speak specifically about the Hamilton District Court and the Alcohol and Other Drug Treatment Court that is to be established there in 2021. In doing so, I make it clear that the pathway forward is one that is intended to include not only the two founding cultures, but to include all New Zealanders of all ethnicities and of all cultures who are affected by the business of our court. It is also a pathway that will respect the independence of judicial officers who will continue to apply the relevant law and decide cases on their individual merits. Our intention will be to ensure, to the maximum extent possible, that the best available information is presented to our judges and our other triers of fact to enable them to make well-informed decisions. I intend to frame these remarks within the applicable constitutional framework. Criminal justice policy and legislative reform in the criminal justice system are both matters for the executive and the legislature. Examples that come to mind are the legislation that established the Youth Court in 1989, and in more recent times, the government funding that has been allocated for specialist services to support the alcohol and other drug treatment courts. As Chief District Court Judge, I have a statutory responsibility to ensure the orderly and efficient conduct of the business of the court. This includes duties around rostering of judges, scheduling of work, setting standards for best practice in the District Court, and to oversee and promote the professional development and education of judges. Nothing I am about to discuss will necessarily require legislative change. Clearly, both the judiciary and the executive have a role to play in the kaupapa of transforming the courts. And both branches of government have to respect the prerogatives and constitutional boundaries of the other. In saying that, however, I do wish to acknowledge the presence of the Secretary for Justice and Chief Executive of the Ministry for Justice, Mr. Andrew Kibblewhite, and the Deputy Secretary Maori, Mr. Marcus Akuhata-Brown, and in doing so, I look forward to working in an appropriate and careful relationship with the executive as this important work continues to be progressed. And I turn now to the first topic that I mentioned, the Maori worldview about this concept of Te Ao Mārama. The District Court response to calls for transformative change has been shaped by this reference to the concept mai te pō ki Te Ao Mārama, which literally means the transition from night to the world of light, the enlightened world. This concept draws on several different threads, including the well-known expression, ka pō, ka ao, ka watea. Ti hei mauri ora ki te whai ao, ti hei mauri ora ki Te Ao Mārama. And in fact, I heard Rahui end the karakia today with that exact expression. Translated, what does that mean? The first rays of dawn herald the transition from night to day. Behold, it is the living environment. Behold, it is the world of light. The concepts of Te Pō and Te Ao Mārama have relevance to the Maori creation myth, when Tāne Mahuta separated his parents by pushing them apart and thereby created Te Ao Mārama, the world of light. This general theme of moving to a more enlightened world is a universal and easy to understand pan-cultural concept. When my father's great-great-grandfather Rangiuia signed the Treaty of Waitangi at Tolaga Bay in May 1840, I do not know exactly what his thoughts were at the time. How could I? They weren't written down. But on an objective assessment, the promises exchanged between the parties to the treaty, at least on their face, created a vision of hope for the future. On one view of it, the treaty imagined the creation of an enlightened world. In other words, it envisaged the creation of Te Ao Mārama, where Maori and Pākehā could live peacefully alongside one another, and both parties could have opportunities to prosper. When Tuta Niho, one of the leading chiefs of my tribe, Ngāti Pro, composed his famous haka Te Kiringutu in the 1870s, he expressed his fury that large tracts of Māori land were being sold to Pākehā settlers, and he was concerned about the future problems that this would cause for Māori people. In the haka, he used the expression pō ngā rā. Those are the opening words of the haka. That is a reference to the law as a shadow that had descended upon the land. In 1877, my mother's great-great-grandfather, Te Maiharoa, led more than 100 of his followers on a migration from Arowhenua, which is just south of Temuka in the South Island, to Te Ao Mārama, which is now known as the modern-day town of Ao Mārama in the Mackenzie Basin. Te Maiharoa and his followers occupied the land and lived in accordance with tikanga Maori for 2 years, consistent with a version of the enlightened world that Te Maiharoa envisaged for his people. Eventually, they were arrested and thrown off the land. When my English and Scottish ancestors travelled to this country in the 1800s, they too were seeking a better life for themselves and their families. They settled in the South Island and at various times married my Kai Tahu ancestors. They, in their own way, were in pursuit of a more enlightened world. From the time of Kupe's first voyage of discovery through until the modern day arrival of immigrants from all parts of the world seeking a new life in our country, the search for a more enlightened world, this idea of Te Ao Mārama, has been a consistent theme throughout the generations. I suggest tonight that the calls for transformative change as they relate to the District Court could be translated as a concerted call to move towards a more enlightened world, to move towards Te Ao Mārama. Not just for Māori, but for all people of all cultures and of all ethnicities who are affected by the business of our court. This is because modern-day Aotearoa New Zealand is now a multicultural and vibrant society with two founding cultures bound together by the principle of partnership based on the Treaty of Waitangi. In modern thinking, the vision of hope that is expressed in the treaty relationship now extends to include all Māori and non-Māori New Zealanders, regardless of ethnicity. Hence the all-inclusive nature of the vision for the District Court. This vision and move by the District Court will still mean some people who need to be held accountable and responsible will still be held accountable and responsible. The Sentencing Act 2002 will continue to be applied, and principled and lawful sentences, including imprisonment, will still be imposed. But we are hoping that this will be in an environment where more well-informed decisions can be consistently made based on better information, with better informed participants, better understood processes, and optimal outcomes. I want to move on to discuss the second part of the title I referred to, relating to calls for transformative change that relate to our court. Calls for transformative change to the justice system have been passed down through successive generations. They are not a modern phenomenon, nor just another worthy contemporary cause. They come from all corners of our society and have relevance not just for the founding cultures, but also for all other cultures in modern-day Aotearoa New Zealand. In saying that, though, the sense of hurt and unfairness driving the calls for change is deeply felt amongst Māori. In the 19th century, these calls were primarily directed towards Māori land alienation and related issues. When the Treaty of Waitangi was signed in 1840, Māori owned almost all of the land in Aotearoa. By 1892, it had reduced to almost a third, and a quarter of that was actually leased back to Pākehā settlers. In the space of a generation, Māori had effectively been transformed into wage labourers with no capital base. During this period, Māori were progressively excluded from the economic opportunities of the new colonial society. As a result of a combination of factors including armed conflict with the Crown, resulting land confiscations, and the devastating effects of disease on the Māori population, by the turn of the 20th century, Māori were considered to be a dying race. The Māori language was banned in schools, certain tikanga practices were banned by statute, official government policies effectively promoted the assimilation of Māori people into the dominant colonial settler culture. In the mid-20th century, the Māori population began migrating from traditional villages into larger metropolitan urban areas. Until that time, the rate of Māori imprisonment was generally proportionate with the Māori population percentage. However, the generation of Māori who were part of the urban drift became a visible and conscious minority and faced further official government policies that required Māori to assimilate into the mainstream. This urban shift and the social and economic difficulties that followed contributed to a dramatic increase in Māori representation in the criminal justice system. Between 1950 and 1970, the number of Māori people received into prisons, compared to all prisoners, doubled. As the statistics continued in this direction, calls for transformative change to the justice system continued to be directed towards the District Court. This trend has continued for the last 3.5 decades. The message underlying these calls for change is that defendants, whānau, complainants, victims, witnesses, parties, and other participants in proceedings are leaving the District Court feeling unheard, unappreciated, misunderstood, and in many cases with needs that remain unidentified and unresolved. By my count, there have been more than 30 reports stretching back over 3 decades, criticising the justice system's approach to Māori and calling for transformative change. In this regard, I'm thinking of seminal reports from the mid-1980s, such as John Rangiho's Puao Te Atatu and Mona Jackson's He Whai Pānga Hou. The next topic I want to move on to is what has the District Court done so far in response to these calls for change. Over the past 3 decades, the District Court has sought to address many of these calls for change by incrementally developing initiatives, including the development of specialist courts, designed to meet perceived community needs. Some of the judge-led initiatives started in the mid-1990s, when judges began embarking on regular marae visits. This was to expose judges to the Maori world. And for many, they had not at that time been exposed to the Maori world, and this was a journey to a marae to achieve that exact purpose, to increase understanding of what the Maori world actually was. This was followed by the development of te reo and tikanga education programs. A Maori advisory group to the Chief District Court Judge was formed. Maori announcements to open and closed court were introduced. And tikanga was incorporated into swearing-in ceremonies for newly appointed judges, which are increasingly being held on marae. At the same time, there has been a natural development of solution-focused judging in our courts. This approach is underpinned by extensive academic and jurisprudential theory. It is not mere trend or fad. It is both evidence-based and legally sound. These specialist courts are heralded as centres of excellence. They incorporate te reo and tikanga Māori into our court processes. They attempt to improve the information that is available to judges. They embrace active and involved judging. They increase community involvement in the court, and they attempt to address the underlying drivers of offending. In simple terms, solution-focused judging seeks to identify the drivers of offending and to then address them by facilitating the provision of services and community support required to restore lives and foster rehabilitation. The first New Zealand example of solution-focused judging that I'm aware of occurred in the 1980s when Judge McBrown, as he was then, referred a Māori defendant to Sir Peter Sharples and sent him to the Waititi marae and asked Sir Peter and the people at the marae to work with that particular man. Since then, in the criminal jurisdiction, we have seen the development of a whole raft of specialist courts, including the Youth Court, rangatahi courts, family violence courts, a youth drug court in Christchurch, the Matariki Court in Kaikohe, the Homelessness Court in Auckland, the Special Circumstances Court in Wellington, the Personal Individual Needs Court in Masterton, the Family Violence Intervention Court in Gisborne, and the Alcohol and Other Drug Treatment Courts in Waitakere and Auckland. There are sexual violence trial courts in Auckland and Whangarei, a criminal procedure mentally impaired persons court in Auckland, and most recently, a young adult list court has been established in Porirua. The District Court has an active criminal caseload of 37,000 matters and deals with 121,000 matters per annum. Specialist courts deal with a relatively small percentage of the overall criminal caseload and tend to be resource intensive. However, specialist courts are recognised as centres of excellence for best practice in the criminal jurisdiction. To improve access to justice for all people who are served by our court, the leadership of the District Court intends to develop a model that identifies the best practice lessons from those specialist courts and incorporate them into the mainstream to the extent that is practicable. The intention being that the maximum number of people should benefit from the best practice lessons that have been developed in our specialist courts. Now I want to address what it is that we are proposing to do in the future. I've talked about the calls for change. I have outlined the District Court's response so far, particularly through solution-focused judging. So where to now? Do we continue with a proliferation of specialist courts that deal with discrete issues, dotted unevenly around the country, and representing a small percentage of the 37,000 active criminal matters that constitute our current criminal caseload? Or do we take a broader, more integrated approach? My answer is that we should do both. It has become increasingly clear that the way ahead is to build a mainstream model on the foundation provided by specialist courts. This will allow us to integrate those best practices throughout the District Court. Approaches that teach us about the value of whānau, hapu, iwi, and wider community involvement, and the power of tikanga in fostering rehabilitation and restoring lives, resonates as applicable and beneficial for all people of all cultures and of all ethnicities. This mainstream approach will be inclusive and designed to increase levels of engagement with all people, not just Māori and not just defendants, but all New Zealanders who are affected by the business of our court. There are several common features of our solution-focused courts that form the building blocks of a mainstream approach. These range from inviting the diverse voices of our communities into our courtrooms, toning down courtroom formalities, encouraging engaged and informed judging practices, coordinating systems and community expertise to identify and address the underlying drivers of offending. Woven through all of this is the incorporation of tikanga into court procedure to enhance engagement and inclusion of all people our court serves. This mainstream model is intended to be a deliberate and comprehensive response to the calls for transformative change, to the way that the District Court delivers justice in this country. We intend to refer to the mainstreaming model as the Te Ao Mārama model. This concept is intended to represent a natural extension of what we have done so far in responding to the calls for transformative change. It should also be seen as a considered and meaningful step towards improving access to justice for all people. I want to turn now to speak specifically about the Hamilton District Court. And in doing so, I want to acknowledge the fact that we have a large representation present tonight from the District Court bench in Hamilton. We have a large representation of the profession, and we have a large representation of the academic faculty in this area, as well as representation from Tainui Waikato. So what I'm about to say may be of some interest. An addiction treatment court is something the Hamilton community has been calling for a long time. Next year in Hamilton, with support from government funding for specialist services, Hamilton's Alcohol and Other Drug Treatment Court will have a stream in the criminal jurisdiction based on the current model in Auckland and Waitakere. But significantly, there will be a new and distinct family court stream that deals with care and protection issues. This stream will focus on young mothers with addictions who have or are at risk of having a child removed from their care by oranga tamariki, and so have come within the sphere of the family court. Notably, this means the Alcohol and Other Drug Treatment Court in Hamilton will for the first time include participants from both the criminal and family court jurisdictions, although on separate tracks. This expansion of the Alcohol and Other Drug Court is primarily about the best interests and welfare of the children involved. The fact is that many of the children who come to the state's attention do so first in the family court. There is more than enough evidence that children who end up in state care go on to have vastly higher incarceration rates. Children and young people living with parents who are addicts are vulnerable to harm and neglect, as well as to falling onto the wrong side of the law. The inclusion of the family court stream as part of the AODT court offers a new path for early and better tailored intervention for mothers with underlying addiction issues and their children. Hamilton District Court will also be the first court in Aotearoa, New Zealand, where the Te Ao Mārama mainstream model will be developed and implemented. We intend to develop this model in a spirit of partnership between the executive, local iwi, and in conjunction with our diverse multicultural communities, non-governmental organisations, service providers, and with the support of the Ministry of Justice and other cross-sector agencies. The Te Ao Mārama mainstream model will recognise that the communities in each court location are different. A one-size-fits-all approach will not work, and flexibility will be necessary to adapt processes in a way that best reflects the needs and special characteristics of individual communities. The Te Ao Mārama model will be designed to draw on existing resources within each community, and it will also attempt to invite the strengths of each community into the courtroom for the benefit of those who are affected by the business of the court, and ultimately for the benefit of the community itself. Our long-term intention is to spread the Te Ao Mārama mainstream model across all of our district courts from Kai Tahu to Invercargill. I acknowledge that the district court cannot do this alone, nor in isolation. I look forward to navigating this pathway alongside iwi, alongside the wider communities that we serve, and with the support of the executive, the Ministry of Justice, and the other relevant cross-sector agencies. In conclusion, I emphasise that none of the concepts and approaches encapsulated in the Te Ao Mārama model are radical. The many components have already been trialled in various forms in specialist solution-focused courts over many years, and they have been found to be both effective and fair. They haven't required legislative change. What is different is the intention to develop the model in partnership with local iwi and alongside local communities to bring the strength of the community into the courtroom. Taking the lessons our specialist courts offer about best practice and targeted evidence-based responses and applying them across the whole of the District Court to the point they are normalised is a logical next step. The intention of the Te Ao Mārama model is to improve access to justice and enhance outcomes for those who are affected by the business of our court. This is intended to result in judges being presented with the best available information to enable well-informed decisions to be made that achieve fair and appropriate outcomes. This is all intended to build confidence in the court process and in the rule of law within the communities we serve, and ultimately to make our communities safer. This pathway towards Te Ao Mārama is clear and well lit. To end this address, I am reminded of one of my grandfather's favourite whakatauki. He iti te mokoroa, ka hikatea teitei ka hinga. Which translates as, even the smallest insect, the borer grub, can fell the tallest tree in the forest, the kahikatea, the white pine. To achieve a great feat, time, perseverance, and commitment are necessary requirements. I commend this approach to all of us in our collective endeavour to reimagine the District Court as a place where all people can come to seek justice, regardless of their means or abilities, regardless of their culture or ethnicity, regardless of who they are or where they are from. And I commend this approach to all of us to make this shared vision a reality. Nō reira tēnā koutou katoa. Kua mutu.
Te rangatira e Heemi koe ke tātou ki te whiti o ngā haora. Nō reira, kua tāi mai te wā, hei te whakakōpani i ngā tātou kōrero i tēnei wā.